How does a criminal trial actually end? It all comes down to this.
The defense evidence, the final arguments, and a judgment deciding guilt or innocence.
Absolutely. A trial's fairness is tested the absolute most at its very end.
Because this is exactly where the stakes are life or death, right?
Exactly. This explainer covers the final verdict in a Sessions Court trial.
So, what does the actual procedural journey look like at this stage?
It is a strictly structured sequence of specific, high-stakes legal events.
And one single procedural mistake here can literally cost someone their life?
For sure. That is why understanding these final milestones is absolutely critical.
Right after the prosecution closes its evidence, what happens next?
We shift focus to the accused and their fundamental right to explain.
First, we will look at the Section 342 examination.
Second up is the defense case strategy under the law.
Third, we weigh circumstantial evidence in a Sessions trial.
Fourth, we break down the sequence of closing arguments.
And finally, the judgment and mandatory high court confirmation.
Okay, Section 1, the Section 342 examination of the accused. The exact starting point of the end of the trial.
So the prosecution rests. How does the Section 342 examination actually work?
Every single piece of material evidence must be specifically put to the accused.
Can the judge just casually ask if they have anything to say?
No way. A general question is totally legally defective in capital cases.
They have to ask about specific things, like eyewitnesses or medical evidence?
Yes, precisely. Every specific motive or forensic finding must be confronted directly.
The accused needs a fair chance to explain every single material circumstance.
Exactly. And the consequences of a defective examination are actually quite severe.
Let's look at Muhammad Sharif versus the state, 2008 SCMR 1234. Ahmer. This ruling proves how vital Section 342 is in a Sessions Court. Failure to put a specific material circumstance actually sets aside the conviction? Yes. The Supreme Court considers it a massive material irregularity. So any unexamined evidence is literally ignored when finding someone guilty? Absolutely. That is the ultimate safeguard ensuring complete fairness for the accused.
Moving on to Section 2. The defense case strategy.
Specifically, the rules found under Section 265G CrPC.
How is the accused formally called upon to enter their defense?
Under Section 265G, they can now officially adduce their own evidence.
This is when they face the ultimate strategic question, right?
Yes. Do they testify on oath, or do they remain completely silent?
Testifying on oath under Section 340 CrPC sounds incredibly risky.
It is. Testifying means they will face rigorous cross-examination by the prosecutor, but they do get to present their direct narrative to the judge.
True, but any inconsistencies can completely destroy their defense strategy. So what is the safer alternative to Section 340?
Giving an unsworn statement under Section 342 CrPC instead.
That completely preserves their fundamental right to remain silent, right?
Exactly. They avoid cross-examination and force the prosecution to prove its case.
But doesn't remaining silent make the accused look automatically guilty?
Not legally. Look at Muhammad Aslam versus the state, PLD 2006.
The Supreme Court ruled silence cannot be used as evidence of guilt. Right. The right to silence means exactly that. It is fully protected. So a judge drawing adverse inferences from silence is making a legal error? A massive one. Silence may never fill gaps in the prosecution's case.
Section 3. Weighing circumstantial evidence in a capital trial. Ahmer. This is absolutely critical when there are no direct eyewitnesses.
How does the Sessions Court handle cases lacking direct eyewitness testimony? They have to rely on circumstantial evidence to infer actual guilt. Isn't convicting someone based purely on circumstantial evidence super risky? Very. That is why courts use strict concepts like the last seen principle, meaning being the last person seen with the victim is highly significant, but it is legally insufficient by itself to sustain a murder conviction. What about recovering a weapon under Section 103 CrPC? An unbroken chain of custody for recovered articles is absolutely mandatory.
So how much circumstantial evidence actually justifies a death sentence? The courts apply what is known as the golden thread rule.
All circumstances must point unerringly to the guilt of the accused?
Yes. And they must be inconsistent with any reasonable hypothesis of innocence. So even one alternative reasonable explanation means they cannot convict? Exactly. Every single circumstance must be individually proved beyond a reasonable doubt.
This perfectly brings us to Muhammad Akram versus the state, 2009. The Supreme Court reinforced the golden thread rule with absolute strictness here. If proved, circumstances match any hypothesis of innocence, the accused gets acquitted. This standard prevents courts from ever convicting a person on mere suspicion. It demands an extreme level of rigor to prevent false convictions. Absolutely. The cumulative effect must exclude every single possibility of innocence.
Moving to Section 4, the sequence of closing arguments. The ultimate courtroom clash under Section 265I CRC.
Once the defense evidence concludes, how does the final clash begin? Section 265I CrPC mandates a very strict statutory sequence for arguments. First, the prosecution sums up their entire case for the judge. Second, the defense is legally entitled to a full, comprehensive reply. And third, the prosecution is entitled to a final rejoinder? Yes, but only if the defense exercises their right to reply first.
What do these legal counsels actually need to accomplish here? Strong closing arguments must clearly identify every single established fact.
They also need to apply the beyond reasonable doubt standard to those facts.
Yes, the prosecution must actively address and dismantle the defense case.
They also need to connect all the circumstantial evidence logically.
And they must address any legal consequences of pardon in qisas cases.
So they are building a watertight, logical chain for the judge.
Finally, Section 5, Judgment and High Court Confirmation.
The legal requirements found in Sections 367 and 374 CrPC.
Let's discuss the final act, the actual judgment under Section 367 CrPC.
In a Sessions Court trial, a bare guilty finding is legally defective.
The judgment requires points for determination in the final decision, right?
Yes, but most importantly, it requires rigorous reasons for that specific decision.
So the judge has to meticulously explain exactly why they convicted?
Exactly. They must engage deeply with both the prosecution and defense evidence.
We see this exact standard in Mohammed Zubair versus the State, PLD 2017. The Supreme Court demands the absolute highest level of judicial reasoning. A judgment merely summarizing evidence without engaging with weaknesses cannot be sustained.
Right. The judge cannot just ignore the accuser's Section 342 statement.
Failing to engage with the defense's explanation means the judgment is void. It ensures every conviction survives incredibly intense appellate scrutiny later on.
What happens when a Sessions Court actually passes a death sentence?
Section 374 CrPC provides a mandatory, non-negotiable safety net.
The proceedings must be immediately submitted directly to the High Court.
Yes, a death sentence simply cannot be executed without High Court confirmation, so the High Court must confirm the sentence before execution is permitted. This guarantees no execution happens without an additional layer of intense scrutiny.
It is a critical legal backstop against any irreversible miscarriage of justice.
A criminal trial's fairness is tested most at its end.
In the defense's case, the arguments, and the judgment itself.